So thank you for joining me today. I'm Amy Schmidt, and I'm here to have an honest conversation with Christopher. So Christopher Hamilton is an elder law attorney, and one of the reasons why I call these conversations an honest conversation is because sometimes with professionals and providers, we tend to talk kind of outside here without really getting to the nuts and the bolts of what really families and caregivers really want to know. So that's kind of why I coined this an honest conversation. So thank you, Christopher Hamilton with Willamette Elder Law, for being here and taking the time out to do this. So first, I've got 1,000 questions. So it's going to be a long video, but I'm going to break it into smaller pieces as well. So first, you're an elder law attorney. Explain to me the difference between an attorney and an elder law attorney, just in a couple of sentences.
So attorney is an incredibly broad license. It's the same basic education and testing and licensure for me, a criminal defense attorney, somebody doing divorces, somebody writing contracts that never talks to people. And so anytime you're doing this, just like doctor, you want a specialist. You want somebody that does the thing that you actually need done. And so an elder law attorney is somebody who specializes in addressing issues related to estate planning, guardianships and conservatorships, Medicaid, and other substituted decision-making options so that we know what to do related to this exact moment, not one thing in 3 years of classes that kind of sounded relevant.
So in law school, everybody gets like a little bit of everything, and then you kind of focus in afterwards.
Yeah.
Okay, so you have chosen to focus in on those, the power of attorney, the guardianship, the estate planning, all of those elements.
Exactly.
Okay. So when you talk about guardianship and conservatorship, that seems like, is that just paperwork, or do you actually act as a guardian? Do elder law attorneys act as that person?
You get a mix amongst the elder law attorneys, at least in Salem and really everywhere. Most attorneys will just do the paperwork and get somebody else appointed. There are a small handful of attorneys that will serve in both the paperwork and the guardian and conservator roles. It takes a lot different kinds of staff support to do that. And just most attorneys aren't willing to wade into that mess.
Okay. So there's a couple things that you said in there, kind of looking at the terms. And this, we're going to share this website. He is licensed in Oregon, but there's also, so you do want to check with your local state, because I do know that people outside of Oregon are looking at this video. So when you, so we've got guardianship, conservatorship, and elder law attorneys. Mm-hmm. So talk to me a little bit about what the difference is between all of these different terms: power of attorney, guardianship, and conservatorship. So let's start with power of attorney. What does power of attorney mean?
So looking at all three, they're talking about alternative decision makers, people who are doing or deciding things for us that are not us. And so with a power of attorney, that's a document that either you and your attorney ideally draft up, saying that this is a person that I trust to be able to manage my finances, and here's the scope of the power that I want them to have in doing that.
So you can limit that to just financial or just to healthcare. How do you limit the power of attorney?
So in Oregon, a power of attorney is inherently a financial document. If we're talking about healthcare, that's a separate thing called an advance directive for healthcare, which then addresses who's talking to doctors if you can't make medical decisions for yourself because you're unconscious, you can't understand what's going on, whatever, and gives them usually very specific instructions about a large number of situations that you might run into so that they know what decisions to make. A power of attorney is usually a little bit lighter on instruction, but it can be structured to cover, just a few financial transactions. Like, usually when you buy a car from a car dealer, you give them a power of attorney to deal with the DMV for the licensing paperwork.
Got it.
And that's all that does. Or you can have a general durable power of attorney, which is a power of attorney for all of my financial stuff that lasts until I'm dead or I revoke it.
Got it. So when you're talking about like the power of attorney, it could be for a specific time frame or a specific transaction. Can the person who gave the power of attorney, can they revoke that? And how is that done?
A power of attorney can be revoked at any time that you actually still understand what's going on, and it can be as simple as writing, I revoke the power of attorney granted to whoever on date, and then making sure that anywhere that you gave a copy of that power of attorney also has a copy of that revocation. That said, please check in with an attorney while you're trying to do this, because that is a rough description of how to do it. That is not instructions on how to go forth and commit legal practice.
Got it. So power of attorney seems to be more financial, particularly in this state. And advanced directives are really more of like, this is what I would like to have. And then is it the document alone with advanced directives, or is there a representative, and what is that person called?
So the advanced directive in Oregon combines two concepts from a lot of other places, what's called a power of attorney for healthcare and what's frequently called a living will. And Oregon just merges those together. And so the advanced directive does two things. It names a healthcare representative to make decisions when you can't. And that also comes with the naming of alternates, so that if somebody can't answer their phone, there's somebody else to call. And then it also includes instructions for those people on, when they get faced with a doctor telling them, this is what's happening, what did you want them to do about it?
So if you've got those pulled together, the representative as well as the living will, what happens is if you've got your wishes written down, but it doesn't exactly play out just like the document. Does the document have priority, or does the representative have priority?
So
if the doctor's looking at who to listen to.
The representative is supposed to be executing the instructions in the document. If we're in a situation that we didn't exactly foresee, which is usually what's happening because our crystal balls don't work, the instructions in the document provide kind of guidance or a starting place to figure out how you view the world and what you value, so that your representative can face the unknown situation and make a decision you would likely have made.
Okay. So it sounds like for these two documents, the power of attorney, particularly for financial, and then this healthcare representative, living will combo, advanced directives, that it's really very important that the person who's choosing the person to carry this out, choosing the person is as important, if not more so, than what the document itself says.
Yes, because it has to be someone you trust, either with complete access to your finances, meaning that there is nothing to stop them from going to the bank, taking out every cent you own and vanishing, other than the fact that you trust them and could theoretically sue them after they do it, but the bank won't stop them. And for the advanced directive for healthcare, this person is making decisions about whether you receive life-sustaining treatment or not, whether you receive surgery or not. This needs to be someone that you not only trust, but have had discussions with about your values, so that they know who you are, they know what you want, and they can actually honor and fulfill those things. You don't want this to be something that shows up on, one of your kids' phones all of a sudden, and they're like, I never had this conversation with mom. I have no idea.
Okay. So it sounds like those two, the person who is picking the person is very involved. So now, is that the same for the other two, guardianship and conservatorship?
So guardianship and conservatorship are default or fallback options if we didn't make a plan. So
the first two
everything goes right. We did an advanced directive, we did a power of attorney, we can use those when the related incapacities show up. If those don't happen, then somebody has to go to a court and ask a judge to declare you incapable of doing either, basic life things or money things, and then name someone to make those decisions and take over that area of your life. And that is someone that is usually self-selected. It's, a spouse or a kid or a friend or some rando who comes forward and says, this person is incapacitated and I should be in charge of their life now. And, sometimes that's somebody well-meaning that's got your best interest at heart, and sometimes it's not.
And so the person, then you're literally going to court with all of the costs of court involved in that. And first you have to deem the person themselves incapacitated. That alone seems to be challenging and strenuous on a relationship.
Yeah, it's one of the more common, I guess two of the more common ways I see this are either a child doing this for a parent or one spouse doing this for the other, and having to look at your parent or spouse and say, I don't think you understand the world well enough to meet your own basic safety needs anymore. It's not a conversation we would like to have.
Right.
And if everything goes right and the person either agrees that that's what's going on or doesn't understand enough to launch an objection with the court, then this can be a paper process. Lots of filings with the court, a court visitor, which is a person with a background in psychology or social work, will come out and talk to whoever is alleged to not have capacity and give the judge a report on whether that's true.
So when they look at capacity, is there a doctor involved in this? Who ultimately decides if a person has enough capacity for themselves or if you do need to take those steps for guardian or conservatorship?
Ultimately, that decision gets made by a judge.
Okay.
And
who doesn't know the family at all?
Right. It is some random person in a black robe who is handing down decisions about your life with usually the court visitor's report to go on. And that's, 10 pages or less.
Got it. So clearly power of attorney and advance directives are the better way to go.
Yes.
So you're involved in those decisions. Okay, so now explain the difference to me between a guardian and a conservator.
So I pulled at this a little bit so far, but guardians deal with the person. And so if we're looking at a guardian, that's someone who's making decisions about healthcare, about where you live, about really kind of day-to-day functioning type things. A conservator is very specifically given power over your finances, your bank accounts, your assets, your incomes, but they're restricted to that financial world. If we're looking at power beyond that, that's a guardian.
Got it.
Frequently, we end up with both.
So one person can serve as both?
One person can wear both hats, yeah.
Okay. Is that typical?
It really varies depending on the person as to whether somebody's got both the capacity to make healthcare decisions and be in that day-to-day role and to make and keep good track of money.
Got it. Okay.
Splitting it actually frequently becomes a helpful conversation when there's family tension over what are we going to do with this, because we can have, the person in the family who's got better healthcare chops take the guardianship role, and the person in the family who's got better financial chops take the conservatorship role, and so there's a little bit more oversight within the family.
Now, do guardians or conservator ever get paid for their services?
If we're looking at a professional, they're always getting paid. They're getting paid if there's money. Which means if it's a conservatorship, they're always getting paid because we only have a conservatorship if there's money to manage.
Got it.
Professional guardians will end up working in situations where there isn't functionally money to pay them, but they try very hard to avoid them.
Got it.
And the money to pay these people comes out of the estate of the person who needs the support. So if you have a conservator appointed for you, you are paying for that conservator. You are also paying for their attorney and any other attorneys involved in the situation in most cases.
So planning ahead really kind of works better, not just for the finances, but also to make sure that your personal wishes are carried out.
Planning ahead is huge, both for the autonomy of having picked people you care about and trust and given them good instructions, and for saving thousands and thousands of dollars. Because even the least expensive guardianship is more expensive than a reasonable estate plan.
Got it. Well, thanks for at least explaining the difference between power of attorney, advance directives, guardian, and conservator. So I've got a couple more questions coming up on the planning of like living wills, trust documents, wills, and all of that. So we're going to do that in the next segment. So thank you.